My lady, if I could just finish addressing you. You, my lords, did ask me about finding that particular paper, and I went through the ACTA judgment and obviously came across, my lady, I know it's not in the bundle, but I'm sure it's very familiar to you, the Getting Married a Scoping paper, which is dated the 17th of December 2015. And that particular paper really sets out the scope for what the Law Commission should be looking at when it comes to addressing marriage in, if I might put it in these terms, in our modern world. Mm-hmm. Do we need an update? And I do note that it is of great public interest of how marriage can be protected. And that does also include sham marriages and forced marriages. And if I could just read out, if you'll bear with me, it's the objectives of the reform, and that's at 1.38 of this scoping paper. And it says, in considering how any new system of law might be devised, we have identified a number of guiding principles which we suggest should underpin any reform in this area. And these principles have led us to conclude that the objective of reform should be to legislate for greater choice within a simpler legal framework. And the guiding principles are set out at 1.39. They are, number one, certainty and simplicity. Number two, fairness and equality. Number three, protecting the state's interest, which we would say would be where forced marriages fall under, and sham marriages. And four, respecting individuals' wishes and beliefs. My lady, if I could just address you on protecting the state's interest, it's at 1.42 of that scoping paper, and says the state's interest in marriage needs to be protected. As a result, one basic assumption of our work has been that there is need for some legal regulation of the process of getting married. There are a number of very strong reasons for such an assumption. At the very least, the state has a role to play in checking the parties' eligibility and capacity to marry, and whether they consent to do so, and in preventing sham and forced marriages. It is vital that any new system does not undermine the state's role in these areas. And then it goes on to say the state also has an interest in maintaining a record of marriages taking place, since marriage affects the status of an individual and gives rise to legal rights and obligations. So, my lady, if you take that, or marry that, for want of a better word, with certainty and simplicity, what we have there is the Law Commission looking at the start of the marriage and saying, actually, should we step in, maybe, and consider that point, and look at whether a person has the capacity to marry before entering into a marriage. And that might be something that the Law Commission are looking at now. That doesn't help us today. What we do have today is, having had the Law Commission looking at the end of the marriage, how to end a marriage, and saying, we'll provide, we believe that nullity and divorce provides certainty. And if I could just also read out one further matter from Dicey's rules, which is at page 501 in the authorities bundle. It's chapter 5. And that's on public policy. And it's just a quote at page 501. And it starts from where there's a tiny little 80, but it says, I don't know, my lady, if you're there, I shall wait.
Just one moment. I'm there.
It says, but if the courts intended to reduce the whole of the conflict of laws, or even that part of it which is concerned with status, to the level of judicial discretion, it is submitted that this is contrary both to principle and to authority. For, as has been well said, to state the law in terms of judicial discretion is to admit that no certainty or predictability is attainable in this matter. And again, the courts might just as well abandon any attempt to formulate and apply defined rules of law if these can be overridden by an undefinable discretion. And as Lord Hodgson said in Boys and Chaplin, rules of law should be defined and adhered to as closely as possible, lest they lose themselves in a field of judicial discretion where no secure foothold is to be found by litigants or their advisors. And that just reinforces that argument around certainty, my lady. My lady, those are my submissions.
Thank you, that's most helpful. And I'm very grateful to you spending time over the short adjournment finding that paper for us. Yes, Miss Lee. Now, local authority.
Yes. And I'll just begin, if I may, by explaining the parties were introduced. And I should also clarify that the social worker for if I may refer to her, Miss Uvera is also in court. I'll just make that point clear. In terms of my submissions and the structure, my lord, my lady, my lords, because of the detailed documents before the court, I was intending to be more brief than perhaps the submissions were heard this morning. I intend to refer to the updated skeleton I filed and the initial skeleton argument.
Yes.
And of course, I'm going to deal, if I may, expand on some points in respect of recognition and exceptionality. And I will, of course, respond, if I may, to some of the submissions made this morning. But again, I intend to complete all of that within a relatively short time, if that's of assistance.
Okay. Well, we've all had an opportunity of reading your very detailed skeleton argument.
I'm grateful. Thank you. My lady, I begin with this point. I do say that at all times the court must have in mind the actual order here that is being appealed. And I'm grateful my lord, in fact, turned to this page earlier. It's in the core bundle at page 86. I'll just deal with that point. And at paragraph 1 of the order of Mr. Justice Newton, I submit that it is relevant that the declaration, as was ordered, speaks as it is not recognised as valid in this jurisdiction. It doesn't say, it doesn't go further than that, nor was any application made for it to be. It doesn't in any way trespass on as to whether or not the ceremony was valid or the marriage in Bangladesh and so on. It might be an obvious point, but my lady, I say it's highly relevant when we look at this appeal. In terms of the also the headline point, if I can put it like that, which I have set out in the documents, is I submit this, and I say that Mr. Justice Newton made reference to Lord Justice Wall, and my lady, my lords, will find this quote in the core bundle at 114. So again, it's in the judgment, but it is this point.
Sorry, paragraph number?
Yes, I'll just 26.
Thank you.
And it's where Lord Justice Wall says that this is a case about recognition of marriage, not about validity. And again, the submission at the centre of the local authority's position is that was the consideration before Mr. Justice Newton. That was reflective of the proceedings that had taken place. And that was important when Mr. Justice Newton took the approach that he did. My lady, I'll turn, if I may, to the person at the centre of this appeal. My lady, there are points I've set out in the updated skeleton argument, but I'll just, so therefore I will be brief, but I do submit it's important because in the skeleton that I've submitted, I set out some of the background, beginning at page 2. In particular, I remind the court as to the education that the young person had received, then a young person. I turn to the, there's a paragraph regarding the circumstances as to the trip to Bangladesh. my lady, my lords now have the supplementary bundle with more detail. I won't repeat, but what is then important are paragraphs 8 and 9. And my lady's already taken this point about when considering a person and assessing all of the issues before the court at this appeal. I do submit that the starting point, because the experts were accepted by the court and there was no appeal to the input, if you like, and the evidence given by the experts, is the specialist mental health assessor and Dr. Lilly. My lady's already turned to Dr. Lilly. I just remind the court that the diagnosis is set out in the supplementary bundle, the reference there, 296 to 297.
Yes, I mean, you say at paragraph 9, moderate intellectual disability, but looking down
Yes.
at 299, it's
Exactly.
extremely low, not
It
moderate.
is. So whilst obviously I've just accurately put how Dr. Lilly in her definition concludes that, I do submit that when one carefully looks at the full range of testing that was undertaken by Dr. Lilly to ascertain the functioning and so on of this person, that the conclusions and the outcomes of that are quite stark. My lady's made the point about the functioning being a very low range and less than 1%.
May I ask just one question while we're on this
Yes.
aspect of it? I mean, in the criminal jurisdiction, you require registered medical practitioners before you say that someone can have a hospital order rather than a prison sentence. In civil jurisdictions, Masterman and Lister requires registered medical practitioners. Here we've got a very experienced mental assessor, but a nurse.
Yes.
We also have a psychologist, not a registered medical practitioner. I accept that the family proceedings rules permit a speech and language therapist to give that, but is there any reason why registered medical practitioners are not used for something which is so vital to the person who's the subject of this appeal?
In terms of why they're not used, I would be in difficulties giving a clear answer or a detailed answer to that. But my lord, perhaps if this assists, I put it like this: when considering applications pursuant to Part 25, in the family court and in the High Court in this case, careful consideration must be given. Of course, there's remit to the judge. It's very clear. My lord will be familiar with Part 25, of course, but very clear, careful consideration is given as to the qualifications of that person. Added to that, Mr. Farmer was also considered necessary to give oral evidence, and his opinions, including and his qualifications, which would be a subject, could be considered as relevant subject for cross-examination, can be put to. And there was no, well, there's certainly Mr. Justice Newton didn't challenge the suitability, and I know my lord's not saying that, but.
And it's plain from reading the reports that these are experts in their field.
Exactly.
But it's just surprising, given the importance of the decision, where in other fields of the law, registered medical practitioners are required to opine, albeit with the benefit of inputs from psychologists and registered nurses.
Well, perhaps if I explain just very briefly, and it is briefly, as to the application that was made in respect of Dr. Lilly, that came about at the adjourned final hearing, and it was an application made on behalf, forgive me, one of the parents. And so it hadn't been considered necessary by the other parties in advance of that, but clarification as to the diagnostic and the functioning of the person was considered. The judge was persuaded that, as we, in context of adjourning as well, it wasn't going to be any matters. So, in answer to the original question, I'm not certain why there's that differentiation, but I do submit that the appropriate use of Part 25 was met in this case, that the application was made and duly approved, and in fact, what then followed, I submit, is that independent expertise to give a very comprehensive overview as to the functioning of the person.
Thank you.
So I do set that out. I also, if I just may briefly refer to perhaps a more practical or day-to-day description of P, of the young person. It's in the judgment, my lady, at the call bundle C102. So this is the February judgment, and it's paragraph 54. And sorry. And it's sort of a third into that paragraph where Mr. Justice Newton sets out it is worth remembering that S was unable to decide about money and so on. And there are a few sentences there which my submission encapsulate the day-to-day functioning of S.
Well, I think it's significant, isn't it, that she's a young person who's not even able to look after her own personal cares.
My lady, yes, it is significant. And so I do draw the court's attention to that point. And the submission made plainly on behalf of the local authority, because it's how we've set our case out, is that in this case, Mr. Justice Newton, in my submission, did, firstly, in terms of the declaration, he was cautious in February and said, I'm actually going to return to this point. He then, there is the adjournment, further legal arguments are prepared and submitted. So Mr. Justice Newton, carefully and properly, I submit, considered the legal test. And then turning to the judgment, if I just may, and this is the May judgment, it begins in the call bundle at 109. And again, I don't wish to go over points which may be obvious, but I just put it as an overarching point. In terms of the approach taken, I just wish to identify in the submission I make that the legal framework is set out. His Lordship goes on to consider, in my submission, carefully and properly the inherent jurisdiction declaration form, beginning at paragraph 16. And then, in my submission, also, I submitted it is relevant at paragraph 29 at 114 and over the page right on to 116. There is a review of the case law looking at the use of inherent jurisdiction, and in my submission it was that careful consideration that was duly undertaken that renders the decision made correct in law. The judge, it was open to him in my submission to rely on the Westminster case. He duly did so, but also had in mind a number of the other cases. I'm going to turn then, if I may, to some of the points that were raised this morning and respond to those. And the point was asked, or it was raised, whether there is a presumption or an understanding that law, family law, in terms of understanding of marriage in other jurisdictions would be a similar approach. And it is, of course, submitted on behalf of the appellant that in Bangladesh it would be considered a valid marriage. The response I make about this is as follows. Firstly, there isn't any expert evidence before the court as to the validity or otherwise of the ceremony, the marriage, and the standing of that, of what occurred in October 2019. There is simply no evidence about that. It could have been asked, I submit, if it was going to then become a point, I submit that there was an opportunity, for any of the parties, but for any application to be made to obtain that. I make a general point, and I make it with caution because I don't want to generalise too much, but I would say that in cases of family law, I take an example of abduction, international abduction, or any case, the starting point in my submission is in fact the contrary to has been put forward, is that there's no assumptions made that laws are the same. That's why experts may be required, or an understanding of the law in another jurisdiction may need to be obtained to consider a number of points. So I just submit that in terms of proceeding on the basis that the marriage is valid in Bangladesh, I submit there isn't evidence in support of that.
Can I ask this question? Do you accept that if parties don't get expert evidence, then the presumption which applies in all other areas of law would apply, namely that the laws in Bangladesh are assumed to be the same as in England.
Well, the difficulty with that is that that presumption is a very broad one to make, particularly on this case, when the issues as now being advanced by the appellant are about validity or otherwise. I accept, and I do, of course, Mr. Justice Newton makes reference to the wedding and to the marriage and accepting that that went ahead and so on. I, of course, don't demur from any general presumptions that are made about laws. I don't do that. But I just wish to highlight that it would be, in my submission, I would respectfully urge caution in trying to assert a positive case that the law must be the same. My submission that isn't reflected. There's no evidence to say that. The other point I wish to address, and this is perhaps a central submission, because it goes to the point about exceptionality. And I'll turn to those points now. And I was going to deal with the submission that was made on behalf of the appellant about extrapolating forced marriage and saying that it's not necessarily always an exceptional situation. But before I do that, if I may, I just turn to the features of this particular case. And in the excuse me. And in the updated skeleton for the local authority, beginning at page 8, there are some more perhaps focused submissions responding to the refined skeleton from behalf of the appellant as to why, in this case, exceptionality is exceptional, essentially. And then, as I say, I'll make some broader comments, if I may, submissions. I've set out at 26A there. This point is made about that there's no evidence that anyone was hurt or threatened. Well, maybe I submit that isn't a relevant determinant, because firstly, this is in the umbrella of a forced marriage situation, a criminal offence has been set out.
Well, the fact that there's not been any physical violence may or may not go to sentence in the event of a prosecution, but it's not going to stop it being a forced marriage, which is deprecated under the rules of this country.
Indeed. And well, then I just make one additional, it's a tangential point, but I also say that having the courts refined and further developed the definitions as well as to domestic abuse and violence and so on, to then I submit that it doesn't follow that anybody being hurt or threatened is a relevant factor.
What you're drawing on the domestic abuse, in other words, the controlling or coercive behaviour, which clearly is part of this, is also domestic abuse.
Indeed, and my lady, I of course refer to the updates in the criminal law, but also the judgments in the family in respect of that test. And the submission also made that, and it's in my paragraph 26A, that the S was suggestible and likely to comply. Lady, to put that point in a vacuum without the context of the lack of capacity of that person, lady, I submit that it falls completely as a suggestion, that as a submission, that in any way this wasn't a harmful or abusive act in terms of what has happened. So I deal with that point there, and then I go on. In fact, I deal with the more broader points as I go through here. But in terms of, I think it has to be right to say that it is not a question of saying, and I'm sort of inviting the court to say, in every single case, full stop, of any forced marriage at all, that it must follow that it's exceptional. However, I do say that it falls very near there, if not there, because of the points I'm now repeating, but I've already said as to the overarching umbrella of the nature of that criminal offence, and the severity of it. So I suppose it, as the starting point, it's difficult, I submit, to see how a forced marriage can never be anything other than exceptional. But perhaps put it that way around and then go on to say, however, each case needs to be considered, of course, on a case-by-case basis. So I do submit that that also is a flaw in the appellant's case when looking at this appeal. In terms of the paragraph C over the page, at page 9, the particular facts of this case I've already raised them. I won't repeat the points I've made, but it is worth remembering that at the final hearing, each parent proposed and offered undertaking to the court as a substitution for the orders being made. And that's obviously now slightly at odds of it being advanced on behalf of the appellant, that the forced marriage protection orders create a form of protection. So I just remind the court of that context. And then at paragraph D, the Westminster case, my lady's already, in fact, commented on the some of the aspects of that case. Lady, I submit that the facts that are similar in the two cases far outweigh any attempt to differentiate S in this case and the person in C. Far outweigh. And the mode of communication, as I've said here in my submission, is not at the point at all. It is about a person who lacked capacity being involved at the heart of what was happening around them. That, I say, is a strong thread between the two cases, very much at the heart of why I submit, in this case, Mr. Justice Newton was right to say that exceptionality absolutely applied. I go on I just turn the page to page 10. There's a case which isn't in the authorities bundle, but I do set out the relevant paragraph where Mr. Justice Mumby, as he then was, dealt in my submission, in the case of Re S.A., a summary of which I submit is helpful when looking at the approach to be taken with this exceptionality test. So I do refer the court to that as well. I go on, there are other quotes, so I won't repeat them, but in my submission there's just one other point I wanted to take the court to, and that is at page 12 of my skeleton, paragraph 35, Lord Justice McFarlane, as he then was, in looking at the inherent jurisdiction, and makes it clear there that the inherent jurisdiction continues to be available. So I'll turn now, sorry, I'll just pause for a minute. So I'll turn, sorry, and just expand about this point as to moving, as has been suggested, one has to have nullity, full stop, before even looking at inherent jurisdiction. In my submission, that isn't a reflection, in fact, of, I'm going to put it like this, the tools in the toolkit that are available to a judge, a High Court judge, when considering these applications. It cannot be right, and it isn't said that there must be a pause and there must be consideration, not just consideration, but a full consideration, an exploration and conclusion as to other options before looking at inherent jurisdiction. That isn't, I submit, how the law is approached in the Westminster case, and it isn't also how the law is approached in other cases of which Mr. Justice Newton makes reference. And therefore I submit that the approach taken by Mr. Justice Newton fell in neatly in my submission with an appropriate case with a person of this particular difficulties and lack of capacity. So, for example, when I turn back to the judgment, sorry for moving around the papers, but beginning at 114, this is the May judgment, of course. When considering the cases, at paragraphs 29, particularly at C, consideration of B versus I, one turns the page, the top of page 115. The points made there at the end of paragraph 17 of the judgment, the inherent jurisdiction was a flexible tool that enabled the court to provide justice for parties where statute had failed to do so. And also, my lady, if I may, at E, paragraph E, Mrs. Justice Parker, XCC, that case there, submit is takes an approach where, and it highlights welfare considerations may be relevant. And back to the case in point before appeal, submit that welfare considerations were wholly relevant before Mr. Justice Newton. And indeed, that brings me on to then looking at the remedies or the solution that the appellant is now seeking for the court. And in my submission, I say that it reinforces why, in fact, the use of the inherent jurisdiction was correctly applied in this case. The remedies considered have progressed on behalf of the appellant from when the original grounds were sought, and there was the move, particularly in the refined skeleton argument, to the use of nullity, as my lady is fully aware. On further explanation of that today, consideration has been given to divorce as a solution. In terms of nullity, I won't repeat, because they're in the skeleton that I've prepared, the practical difficulties. But it isn't just the practical difficulties. I make a submission on behalf of the local authority which stopped the local authority from further pursuing nullity. Yes, practical difficulties were one of the reasons. That is clear, and that's set out. But the approach from the local authority in my submission was the other way. It is, what is the right remedy in this case? What is it that the High Court judge is being asked to do? And that is, I revert back to the overarching point about this was a case about looking at recognition of marriage and not the validity. Because the evidence of the social worker and the local authority submissions were the declaration was what was required to help this person, because it was a declaration as to about not recognising their marriage. That was the answer that the local authority sought and was granted. Because looking at the other routes, nullity, notwithstanding, we know we're out of time as a remedy now, but if we weren't, what would be the reality of that situation, I submit? What would be the reality of the S, the protected person, achieving that as a remedy? And how, I submit further, does that even sit with the position of the parents, if I can put it like this, in this case, who wish the marriage for their daughter to continue, and their primary position, I say, as set out in the skeleton argument, was that with some further education it's hoped that that would return. Well, if the nullity petition, as it was called, now is pursued, then that would even be, in my submission, an even more stark end to that marriage. But irrespective of that, it's the time it would have taken. This is a person who has had some depression. She's had emotional difficulties arising from all of these proceedings. it is unclear why pursuing such a lengthy procedure would in any way be in their best interest. If nullity was the solution sought, there was no application at an earlier stage for, say, a best interest decision to proceed with that. There was no further or detailed consideration as to those practicalities. My lady's already said the point. I accept it's not a central issue, but the role of the husband, putative husband, if I can put it like that, in the case, how to communicate with him. I accept it's not a central issue, but these are all matters that if the rights, as it's now put, of that husband were in fact going to feature as an appeal aspect, then I submit they should have been raised at an earlier stage. And an alternative is now raised, that of divorce. Well, my lady, we don't have expert evidence as to any impact, how that might fit in terms of cultural ramifications, and what scenario is that actually going to put this person in. I submit that it is not a solution. What the person at the heart of this appeal required is what was ordered by Mr. Justice Newton, because by dealing with what is not recognised in this jurisdiction, that created the framework to enable those working with SA to continue to work. Any other remedy, such as nullity or indeed divorce, would have involved, I submit, years, certainly a long time, of further litigation, started by whom it's not clear, as already pointed out. The local authority, it wouldn't be for them to bring the petition and so on. It would be extremely complicated. And so it's for all of those reasons that we say now that the remedy sought, or the options before the court, if the appeal is allowed, none of those fit with the facts of this case and what is in the interest of the person at the heart of it. My turn for a moment.
Of course.
Briefly. Thank you. Unless I can assist any further, those are the submissions.
No, thank you very much. That's most helpful.
Thank you.
Yes, Mr. Haddon.
Thank you. If we may just rearrange the furniture.
Of course.
Thank you.
As with everyone else, Mr. Haddon, we've had the benefit of your updated
Yes.
skeleton arm argument, which we've all read.
Yes, no, I'm very grateful for that indication, my lady. And I apologise for the delay in which it was provided, but it
No
felt
apologies
better to-
necessary.
I'm very grateful for that indication. Just before I start substantively, and because I made a brief note just to say it while I remember, the Law Commission, as I understand it, have now published their report.
They have.
It's the 18th of July
Yes.
of last year.
Yeah,
It's 475 pages.
it is. It's
I haven't
very-
had a chance
yes.
Haven't you read it over the
Do word search.
Yes, and that's
Well,
exactly what I've done. But,
Comes. Okay.
even forced marriage comes up a number of times, but certainly as putting a gloss on what I've read, it appears that there's very much a preference to ensure that a sham or forced marriage is not entered into.
Yeah.
But it is
focus is
perhaps
on the
silent-
beginning, not unravelling.
Indeed. May I also say, on behalf of SA, through the Fifth Solicitor, we fully endorse the submissions put forward by the local authority, and are here essentially to also now assist the court in answering any questions you may have about this.
Can I ask one question while it's
Yeah.
in my mind? And it may be that I need to ask Mr. O'Brien the answer to this question, but had SA been to Bangladesh before she went for the marriage?
My
It's just I
recollection
see
of the evidence was that she hadn't been for quite some time, if at all.
Just I recommend there was a reference, I think, in Mr. O'Brien's skeleton arguments to them going on the holidays.
Yeah.
Now, my experience is it varies enormously how regularly families of Bangladesh origin actually get the opportunity to go to Bangladesh.
If I may just Yeah, I'm very grateful. Page references. Thank you. I'm very grateful to Ms.
Thank
Lee
you,
for
thank
this.
you.
It's SB 63. It's the witness statement of the father
Yes.
who confirmed that Essa had not been to Bangladesh since 2001.
So she'd have been how old then?
She would have
Someone do the
been
sums for me.
On one occasion, she'd been there in the past.
But 2001, she'd have been how old? Two.
two.
I think.
And of course, as we know, she paid for the trip to Bangladesh out of her own
It was
savings.
paid out of her money.
Indeed,
Don't
paid out of
think
her
she
money.
Paid.
Yes, well, yes, you're quite right to correct me on that. So, in terms of just a structure of how I propose to address you, firstly, to reconsider the declaratory order that the court has, the effect of that, then look at public policy and perhaps respond to some of the points raised by my own friend for the appellant, touch on the statutory framework, then look to exceptionality, and then finally, you'll see in my skeleton argument, I've addressed the multi-agency guidance, which I have to confess was an oversight at the bar, at least making that known to Miss Justice Newton. I'm not sure it would have made a material difference to his decision, but I submit it is relevant because if this court does conclude that a declaration of non-recognition is appropriate in circumstances, then it's a mystery to me why it does not feature in that legal protection section in the multi-agency guidance, but I'll come to that in due course. So in terms of the declaratory order, Ms. Lee has already taken you to the precise terms of the order, which were this, that the marriage of SA and NU, which took place by a ceremony on or around 25th of October 2019 in Bangladesh, is not recognised as valid in this jurisdiction. The first point I make in respect of that is that squarely falls within the declaration that was made by Westminster, by the Court of Appeal in the Westminster case. And that is confirmed where it was Lord Justice Thorpe who allowed the appeal in part and said the following, and this is at page 253 of the authorities guide. When allowing the appeal in part, and this is at paragraph 32, at the bottom, just above paragraph 33, he said, I would propose a declaration that marriage between IC and NK, valid according to the law of Bangladesh, because of course in that case they had evidence on the validity of the law, the marriage of Bangladesh, is not recognised as a valid marriage in this jurisdiction. So it's a simple point to make, but it squarely fits within the territory that Westminster were considering in terms of navigating their way through the statutory framework and what was prohibited and what was permissible, as it were, under the inherent jurisdiction. So we're left with a declaratory order. Submissions have been made on behalf of the second respondent, the father in this case, which is an appeal to certainty. My submission in response to that is that you have a declaratory order here. It's applicable throughout the jurisdiction of this country. It provides a degree of certainty that this marriage is of no legal effect in the UK. Similar observation was made by Mr. Justice Mumby, as he then was, an ex-City Council and MB, and of course this case preceded the Westminster judgment, and that's at page 304 in the authorities London. And it's paragraph 35. And he says this, he says, the one thing which in my judgment is quite clear and has ever been since the House of Lords in Brook and the Court of Appeal in Sotomayor against the boroughs, is that capacity to marry, in contrast with formal validity, is not governed by the lex loci celebrationis. So it is neither here nor there that a marriage celebrated in Pakistan might be recognised as valid in that country. Sorry. The short point is that MAB's incapacity to marry in the eyes of English law means that no marriage entered into by him, either in this country or abroad, will be recognised in English law. And it's the final sentence I wish to emphasise. And if it is not recognised in English law, it will not be recognised by English public authorities. And perhaps
that's the conundrum. The conundrum is applying, as you say, the conventional view as to which law governs capacity. This is not a valid marriage.
Yes.
But so far as remedy is concerned, in Section 12, the remedy is a decree of nullity, and the marriage is, under Section 12, voidable, not void invalid.
Yes.
So how do those two fit together?
In terms of the remedy under Section 12 of the MCA 1973, that, in my submission, is doing two things. Firstly, it's dealing with status of marriage. You reach a declaration is made of the validity or the voidability. You make a declaration as to whether or not the marriage was voidable, but it also then provides a gateway into financial remedies. So it's performing two functions effectively. Where the Court of Appeal felt comfortable in drawing a distinction was saying, well, when we're saying we don't recognise this marriage as being valid in this jurisdiction, we're not commenting on validity or status. We're talking about recognising the legal effect, and that's perhaps where the language becomes quite slippery.
Well, I mean, that's what Lord Justice Wall was, in his judgment, was saying, particularly in paragraph 60, that as a matter of English domestic law, Section 12C renders the marriage voidable rather than void. It does not, however, follow that the English courts are bound to recognise the marriage as a valid marriage.
Yes.
So there are two sort of strands in a way. One is validity, invalidity, or you do recognise as a marriage, the courts recognise a marriage as valid or not valid, and the second is the remedy provided by Section 12C.
Yes.
And which stipulates that it's voidable, and they're sort of parallel but not inconsistent.
No, they're not inconsistent. Of course, the Declaration of Non-Recognition does not provide a gateway to financial remedies. That's the same with, and I'll address you on the subsist point, the Section 55(1)(c) as well. That's a separate issue. You also wouldn't get a remedy in respect of financial relief with a declaration that a marriage did not subsist at a particular date. So you don't have that gateway to financial provision, as it were. My submission on this is
going back, but just going back to what Mr. Justice Mumby said, he's, as you pointed out, he says that as a result of the incapacity, no marriage entered into by him will be recognised in English law.
Yes.
How does that square with Section 12? In other words, if it's never recognised,
yes.
How do you? And what happens if somebody doesn't bring proceedings within Section 12? Is it nevertheless an invalid marriage, even though it hasn't been declared void? It seems slightly inconsistent.
That is inconsistent. I acknowledge that. The statutory framework is, as identified by Counsel for the Appellant, which is, of course, that a marriage which is entered into by a spouse who lacks capacity is a voidable marriage, but remains valid until it's otherwise annulled. And Section 16 of the MCA 1973 provides that statutory provision. So it's not just case law; it's enshrined in statute. In terms of the inconsistency, I can well understand why you may be troubled with that, but the effect of the declaratory order, I'd submit, does provide an adequate degree of certainty in respect of what may happen if you seek to try and then rely upon the status of that marriage, whether in an
I
immigration
see that.
context.
Sorry,
or
what
benefits.
the point I was actually making is that the Lord Justice Wall seems to be saying that the marriage is valid until there's been a decree, whereas Mr. Justice Mumby is saying is effectively doesn't exist. It's that I'm questioning.
My submission on that would be to prefer the Westminster
Right.
formulation of that,
Yes.
which is to recognise that it's effectively valid until annulled. It's a voidable marriage, and I've already you're familiar with the implications for that. But and Westminster, I should stress, is only dealing with voidable overseas marriages. I would not take it as implying a more general finding in respect of void marriages. My submission would be is you could not rely upon Westminster to deal with a void marriage. And I was going to come on to it, but that's why I submit that the reliance upon Mr. Justice Holman's decision, the local authority in X, is misplaced because he is dealing with a void marriage.
Right.
That was his finding. And in the body of that judgment, he expressly concedes and acknowledges that if it were a voidable marriage, then Westminster would apply. But he says on the facts of that case, which was dealing with a 14-year-old girl, he says, no, this was a void marriage.
You can't give us the reference
Yes,
to that, can you?
that is... Yeah, so it's at page 175 of the authorities bundle, and in particular, paragraph 24. I'm not going to read them all out, but he addresses paragraphs 24 through to 33. He's expressly dealing with all of this, and why he says, in effect, he refused a declaration being sought, which was a declaration of non-recognition, because on his analysis of the facts, the overarching factor was it was a void marriage due to being underage. And so, as a consequence, he felt then bound by section 58(5) that he could not make a declaration which effectively amounted to saying that at its inception it was void. But to say that he's perhaps, well, paragraph 24, he says expressly, there's a line of authority both at first instance and the Court of Appeal, where in certain circumstances courts have made declarations that a marriage contracted abroad is not recognised here for one reason or another. And then he goes on to paragraph 25, he says this case, however, is very different. Is different, and the reason for that is because it's a void marriage, not a voidable one. My Lord, you've already touched on Lord Justice Wall's distinction between trying to recognise or deal with recognition and validity, and trying to draw a difference between the two. My respectful submission, Mr. Justice Mostyn does not grapple with that distinction in his decision. And it may be why it leads him to the conclusion that a declaration of non-recognition is symbolic or perhaps tokenistic. And he expresses that concern at the end of his judgment, which is, the court will be aware, was his obiter comments in any event. I can give a reference for that if necessary. Yes, it's at page 59 of the supplementary bundle.
Do you mean authorities?
Authorities bundle, sorry. page 59 of the Authorities Bundle, paragraph 99, where he says, in his view, a declaration of non-recognition of a marriage does not enhance the power of the court to protect an incapacitated spouse. And then he concludes that paragraph by saying, therefore, the declaration made in each of those cases might be regarded as merely symbolic.
Sorry, paragraph number?
Paragraph 99.
Thank you.
My submission in this is that Westminster clearly disagreed that it was requiring before Mr. Justice Mostyn's decision, but clearly did feel it was of value and importance and provided protection. The making of a declaration of non-recognition does not preclude bringing nullity or even divorce proceedings at a later date. And that indeed was recognised by both Mrs. Justice Parker in XCC and Mr. Justice Hayden in the case of RS. I'll come to those in a moment because they also touch on public policy. But so simply because Mr. Justice Newton in this case made that declaration and chose at that point not to go down the route of nullity, or at least make a best interest decision as to whether or not those proceedings should be conducted, it does not preclude it. In effect, it holds a protective cover over a vulnerable adult who's been subject to a forced marriage, and in all those interactions with the state at which the status of a marriage may become a relevant feature, you have a declaration of non-recognition. Now, I accept perhaps the state doesn't always fully understand what a declaration of non-recognition does, or its ambit, but in my submission, ignorance of it, or poor understanding about it, is something that could be remedied by this court today, in respect of conclusions it reached, and providing a bit more in respect of structure and boundaries as to what the declaration is doing. And so I would invite my lords to grapple that if possible. So moving on to public policy, I'll be brief about this because the questions have been asked. In terms of public policy, of course, evolves, as we know. In terms of, it's not simply what Parliament has said, although pausing there. The point's already been made that forced marriages have been criminalised. Originally, Part 4A of the Family Law Act 1996 did not have that element, but the Anti-Social Crime and Police Act 2014 criminalised forced marriage, and then also the breaches of an FMPO.
And there was a big debate as to whether that was prudent.
Yes, because of the
decision was taken that it was the right thing to do.
Yes, and because there's enormous cultural implications with such cases, and it's incredibly delicate and sensitive, but Parliament erred on the side of, well, we think it's sufficiently important to effectively impose criminal sanctions upon such things. I note that the appellant has conceded that a forced marriage, in respect of the definition of it, because sometimes you can end up in degrees of forced marriage, and I'd submit that Miss Justice Mostyn's decision of NB and MI perhaps leads into that chain of thinking, and I'll come to that in a moment. And I'd submit that the appellant in this case has fallen into that trap, and that's why I wanted to make the submission very loud and clear, which is that a forced marriage, if a person lacks capacity to enter into that marriage, it is a forced marriage, full stop, irrespective of motive, even with the most benign of motives. That is what forced marriage has been recognised both by statute and in the case law, and also in guidance. So it's to say anything less in my submission is simply just is unlawful. So you have that element of public policy. You also have the decision of Cheney and Cheney, which has been cited already and was relied upon in the Westminster case. And the particular paragraph, this is at page 343 of the authorities bundle. And it's halfway down the page. It's directly quoted in Westminster as well, but taking to the original sources, it says, I'll start here just above capital D, which is on the margin. If domestic public policy were the test, it seems to me that the arguments on behalf of the husband, founded on such inferences as one can draw from the scope of the English criminal law, prevail. That echoes my submission about the taking into account English criminal law. And then it's, moreover, they weigh with me when I come to apply what I believe to be the true test, namely whether the marriage is so offensive to the conscience of the English court that it should refuse to recognise and give effect to the proper foreign law. And in deciding that question, the court will seek to exercise common sense, good manners, and a reasonable tolerance. And that was the approach adopted by, incorporated by Westminster when applying public policy. And
So do you think
yes,
this was 1962?
it was.
So I think it'd be pretty unlikely we'd refer to good manners.
Yeah.
But do you think now we would be saying appropriate respect for the foreign countries' culture and ethos? Something along those lines.
Yes, I would.
Good manners seems to me to a respect for the other country.
Yes, it's a very sort of English, perhaps stiff upper lip of recognising what is respect and tolerance and say good manners, sort of decency.
Yeah.
But I agree with that as a reformulation. It's the point of my submission is trying to say that it's not simply what Parliament has said by means of the statutes it has passed. But even then, if we turn to the Law Commission report, and I'll just say it very briefly, it was said in submissions by my learned friend that the Law Commission report, which deals with declarations around marital status, that it's full of mentions of voidable marriages. It's not. There's no mention of voidable marriages at all in that report. It's principally focused upon that a marriage in respect of that is that it's not valid at inception. And I should perhaps preface that by saying that was done with a hasty rereading of that particular, and I'm happy to stand corrected, but that's my reading of the Law Commission's report. It grapples with void marriages, clearly, but it doesn't deal with voidable marriages. And Mr. Justice Mostyn, in his view, he thinks his overture comments on this was that the report does. And so, and Mr. Justice Mostyn says this in his judgment at, this is at page, sorry for jumping around like this.
Right.
So it's page 46. And it's paragraph 52 and 53. But he specifically says, paragraph 53, it is clear when the Law Commission spoke of the petition for a degree of nullity of a void marriage, it should be decree of nullity, it was not merely speaking of marriages void ab initio within section 11, but was also including voidable marriages within section 12. His rationale for reaching that particular interpretation of the Law Commission report is that he says this is demonstrated by the reasoning in the report at paragraph 3.18, that the statutory prohibition should exist principally in order to prevent the evasion of ancillary relief powers that a decree of nullity would give rise to. He's correct in recording what paragraph 3.18 is dealing with is concern about the lack of protection or their circumvention, as it were. But to go so far to say that the Law Commission were clearly considering voidable marriages, in my submission, is a step too far. While we're looking at the Law Commission report, in terms of, I think it was in response to a question from my Lord, Lord Justice Dingemans, in respect of the subsists, the section 55(1)(c) declaration that is potentially available under the Family Law Act as a declaration. Firstly, my understanding is that if one applies for declaration under the FLA 1986, that comes with its own procedural regime. I understand, I was trying to check this over the lunch break, but it was not straightforward. I understand that it does not provide a gateway into financial remedies. And the purpose of including that provision in section 55 is expressly dealt with in the Law Commission's report. And that paragraphs 3.8, sorry, 3.7 and 3.8, and they set out the circumstances.
Sorry, which page?
It's 363 to 364. The circumstances in which one might seek a declaration regarding the subsistence of a marriage whose initial validity is not in question. And in the interest of time, I will leave my lords, to read those two paragraphs, but clearly my overarching submission is that they do not apply to the facts, or they do not apply to the circumstances of the case that we have before you, which is a forced marriage and a spouse lacking capacity, and in effect avoidable marriage. So it's dealing with something very different. So, and finally, the point on public policy is returning to Dicey, and this is at page, it's Rule 5, that in terms of the commentary, at page 494, over the page to 495, when reflecting on the commentary from Dicey, which is, as we know, great weight is attached to Dicey when the courts consider it. It's routinely quoted as a source in regard of conflict of laws cases. But this is paragraph 5005. What's usually in question is not the foreign law in the abstract, but the results of its enforcement or recognition in England in the concrete case. And over the page, it says, everything depends upon the nature of the question which arises. And at the end of that paragraph, public policy in such cases is not absolute but relative. I make the point because you will have seen from the written submissions that the official solicitor's view is that the appellant, and also by extension Mr. Justice Mostyn, has perhaps placed a too stringent approach to the application of public policy in such cases. And that's reflected in at the end of Mr. Justice Mostyn's decision. He expresses the view that applying that very high exceptionality, as he describes it, he himself would not have made a declaration of non-recognition on the facts of the Westminster case, in fact any of the cases he's considered, because of the availability of nullity. In my respectful submission, I would say that's a step too far, and it's placing exceptionality to the point of, well, it's in what circumstance could it ever apply? I endorse the submissions made by the local authority on this point about the applicability of public policy, and again they were echoed by Mr. Justice Hayden in RS, and it's his final part in paragraph. This is at page 170 of the bundle, the authorities bundle. Mr. Justice Hayden was recognising that it was a discretion to grant the relief, but in his view, on the facts of that case, they were so overwhelmingly in favour of making a declaration. He hesitated to say it would apply in every single case.
Sorry, which paragraph?
This is the final paragraph, paragraph 52. But he does make this generalisation. He says, in most cases, an overseas marriage entered into by an individual who lacks capacity to consent to either sexual relations or marriage is likely to require the court to make a declaration of non-recognition. Says there will be more direct remedies in the case of a marriage contracted in the UK. He's not prepared to predict the circumstances in which the discretion might be exercised against making a declaration of non-recognition, but he says, he concludes, those circumstances are likely to arise very rarely indeed, and they've not done so here. Mrs. Justice Parker in XCC makes similar observations about just the nature of the sorts of cases you're dealing with when the potential relief of declaration of non-recognition is in play. That's in my written submissions. I won't turn to them now. Turning
What's
to
the paragraph?
So,
you have
yes,
judgment again?
So it is. So paragraph 63 of my skeleton argument, and Mrs. Justice Parker's particular quote where she identifies the features which she says clearly means that public policy should apply. It's paragraph 72 of
72.
72 of the judgment, and in the authorities bundle, that's page 197. She also goes further, whilst I said I wouldn't speak about Mrs. Parker's decision, but I will make the final comment in that she not only looks at the personal consequences to the individual concerned, but she also identifies there's a wider public policy interest in the court stating openly that such marriages should not be recognised. And pausing there, in my submission, faced with the facts of this case, what was Mr. Justice Newton to do? In respect of, he made findings about a lack of capacity, both in respect of engaging sexual relations and to consent to marry. In my submission, it was so sufficiently offensive to the conscience of the court that the court could not simply sit back and do nothing, as it were. And that's what led him to reach the decision he did, which was as we know, to grant the declaration sought. It's been suggested that Mr. Justice Newton felt that he was bound to make that declaration. He wasn't. He felt bound in response to the submission that the court had no jurisdiction to make such an order because of some of the comments made by Mr. Justice Mostyn in his decision of MB and MI. In response to that, he says, no, I'm bound by precedent. There's relief available here. But then he goes on to clearly identify the reasons why he then thought it was appropriate, necessary and proportionate in this case to provide, to make a declaratory order in those terms. Looking then at the exceptionality, just the facts of this case, as identified by counsel for the local authority, there are commonalities, I'd submit, between the Westminster case and this case, and I've set them out in my supplementary skeleton at paragraphs 12 and 13. I can go through those in more detail if that would assist, particularly the factors I've identified at 30A through to F.
No, we have those, thank you.
But the conclusion I'd submit in respect of that is that it falls comfortably within the public policy grounds which were identified in Westminster.
Sorry, what paragraphs?
So it's paragraphs 12 and 13 of my supplementary letter.
Yes, right, thank you.
If it assists, I can address my Lord's question in respect of why no registered medical practitioner.
Yeah.
I have to confess, I specialise more in the Court of Protection, so this issue routinely comes up. And there's no requirement in the Act as to who should assess capacity. And it's recognised even in the Code of Practice that perhaps even a social worker could assess capacity. There's case law, which I can provide to your Lordship, my Lord, if necessary, which identifies in some cases a social worker might be better placed than a medical practitioner to assess capacity. It depends. It's a question of weight, essentially. Dr. Lilly, in this case, is of course a consultant clinical psychologist. She was asked specifically not to assess capacity, but to assess level of functioning, which in my submission, she was the most appropriate person to assess that. A psychiatrist could not do that.
No, that's always going to be the psychologist, but what you lack then is the psychiatrist's input. For example, whether this is moderate learning difficulties or I think you suggested that was putting it a bit lightly.
Yes, it's in terms of moderate, that is a term of art. Moderate learning disability, you can see that description. It can also relate to the adaptive functioning of an individual. So someone who may have a very low IQ or perform in the 0.1 percentile in other respects, but may be able to cope on a day-to-day level in other respects. So it's more complicated, but moderate learning disability doesn't quite capture, I'd submit, the particular presentation of essay in this case.
I actually, given that this was something that my Lord had been thinking about, we looked together at the COP3 form, which actually sets out who can do it and the list that's there, which of course does include a psychiatrist.
Yeah.
But I think often because we're often dealing with dolls,
yes,
or we're dealing with care homes and things of that nature, that very often social workers or registered nurses that are registered in order to carry out capacity assessments,
yes,
would routinely carry out those type of capacity assessments. Query whether it having been brought to the front of our mind, whether in the most serious cases, and of course all cases regarding capacity are serious, but if you've got an elderly person who is safe and the assessments necessary to provide for their future care, very different from a forced marriage case or cases where you're talking about capacity to marriage or perhaps sexual relations. So perhaps a bit more thought ought to be given sometimes by all of us that deal with this sort of work.
Certainly, and
as to when we should have a psychiatrist or a specialist psychologist.
Certainly, and I'd submit that Mr. Farmer in this case enormously experienced as a mental health nurse. What he perhaps couldn't have been able to comment on formally was the diagnostic element of the capacity, but that had already been established that she had a learning disability. There was a question mark as to the extent of that, so that's why he was able to incorporate that finding by a medical professional and then looking at her functional ability to make decisions. But
of course, a psychologist is not a medical professional.
No, indeed.
And it's just, given the orders we make in criminal courts, which obviously affect people in a profound way, but if you're making an order that you, individual, lack capacity to marry or have sexual relations for 5 years, that's worse than many sentences we pass.
Yes, absolutely. Of course, you have the Mental Health Act, which deals with Section 3741 orders, and it specifically requires Section 12 doctors. As I said, there's no equivalent provision in the Mental Capacity Act. But I can only agree with the observations made. In the most weighty cases, you want to have the best evidence, and particularly with the consequences that may flow in a case such as this, which, as my lady, my lords, you'll be aware, have caused SA enormous distress. Yes. In terms of I was going to end on speaking to the multi-agency guidance, because it only follows from what I've said previously, which is that if this court is to, well, you're bound by Westminster, but if we're going to put perhaps some flesh and bones, as it were, on what a declaration of non-recognition does or doesn't do, then it should be recorded in the multi-agency guidance of my submission. It's a matter for this court as to how it may choose to do that. It may choose not to, but certainly it does seem to be a deficit within the range of legal remedies available following a forced marriage. If I may just turn my back.
Of course.
Unless I can assist with any further.
Where is that? Where's it deal with that in the guidance itself?
So, so the guidance is contained in the. We didn't trouble your lordships with the entire guidance in the selected chapters.
Very grateful.
And it's at page 503.
And the relevant bit about that you were saying about remedies.
Remedies is chapter 16 under legal protections, and you'll see, and that's at page 519. It deals with, as I touched on, the criminalisation of forced marriage. Looks at validity, but doesn't mention the declaration of non-recognition. That's at 16.3. It looks at FMPOs. And then the next remedy it considers is undertakings instead of an FMPO. Then you're into part 4 of the Children Act, so emergency protection order, care orders, supervision orders. It deals with inherent jurisdiction, but only in respect of children and young people, young persons, i.e. under the age of 18. That's at paragraph 16.13. Tip staff orders, and then into the range of remedies, civil remedies under the Family Law Act 1996, so the non-molestation orders, occupation orders, restraining orders under the Harassment Act. So that's my simple submission, is that it seems to be a glaring omission. If this is to be a remedy that's available to the court, and it won't be excised in every circumstance.
Who publishes this?
It's joint guidance published by the Home Office and the Foreign and Commonwealth and Development Office.
Me glancing through it, may need a little input from a specialist family lawyer.
Yes. Well,
if we look at 16.13, no mention of Section 100 of the Children Act.
No. I made similar observations from the perspective of a lawyer who works under the Mental Capacity Act primarily, but yes, it certainly requires some input. I should stress it's split into two parts: statutory guidance, which is published under the I think Section 63Q of the forced marriage protection provisions, but then there's also practice guidelines, and these chapters squarely fall under practice guidelines. Unless I can assist my lady and my lords any further.
No, thank you very much. Thank you very much. Yes, Mr. O'Brien, reply. Anything?
Yes, I'll be very brief, milady. Milady, I'm grateful to my learned friends, Miss Williams Howe, but just drawing my attention to a reference in the new report, the 2015 report of the Law Commission, which is on page 60 at paragraph 3.35, where the Law Commission confirms that a forced marriage will also be voidable. I take it no further than that. It's just that the Law Commission has confirmed that, and there is a small reference there.
Sorry, page 60.
Yeah, page 60
Of
of the 2015 report, which is entitled Celebrating Marriage, a New Wedding Law.
Is it in the bundle?
No, it's not in the bundle.
Ah,
No.
okay.
sorry, what? So which report?
The new one, 2022,
Right. Okay.
Ah, right, okay, I've got
yes.
it now.
and it's entitled Celebrating Marriage, a New Weddings Law, and there's the proposals from the Law Commission, and
Yes.
it's at page 60 in the middle of the page, where the Law Commission just confirms the situation and refers to the current legislation. That is
Some forced marriages may be void if there's age issues.
yes, indeed, that must be the case, but that's not what. All I'm doing is referring to what the Law Commission said. I won't reply, as I say, in any detail. Merely to say this: that as far as public policy is concerned, when there is a move into the inherent jurisdiction, then the court has to focus then on what is public policy, and the temptation is to look at all the case law. But there is actually public policy. And yes, there are new statutes, which Milady has identified, including the forced marriage legislation and other legislation. And all of this is what the courts will need to have cognizance of. But the court also has to ask itself, what is the current situation in terms of public policy, and how was it set out, and what's the evidence for that? And then go back to the statute, and then go back to the Law Commission report, which is broader, and that is where public policy is first identified. Of course, it is developed over time, and of course, the public policy, which we had in 2 decades ago, will not be the same public policy as we necessarily have today. It may have changed somewhat, but we have to look for the evidence of that change. And the evidence where Parliament has passed an act and not amended it is not evidence that they have chosen not to amend it, it's evidence that it has not been amended, and that therefore the policy behind it has not at this stage changed. And that needs to be paid account of when a judge is considering what is public policy, because there is a risk, and in my submission, Justice Parker fell into that in XCCNAA 2013 at paragraph 52, where the question is asked whether inherent jurisdiction needs to be there to fill the gap. Well, there isn't a gap. If the legislation is there, there's no gap. And therefore, yes, the inherent jurisdiction is there to fill the gap, but if the legislation and the public policy behind it is still there, then the gap may not be. Milady has referred to the particular circumstances of this individual case, and it's always the wish of the court to do justice in an individual case, of course it is. And nobody is suggesting that this case did not involve a forced marriage for the reasons that Mr. Haddon quite rightly outlined. It was a marriage without consent in any event. And this is a suggestible individual, and the lady has identified the report and the level of cognitive ability of the individual. So all those are factors. But those are the sorts of factors which in my submission would have been considered, and no doubt were considered, in the more recent report. But these are still voidable marriages. These are still...
Sorry, in which report?
The most recent report of 2022.
But that was talking about celebration of marriage.
It was.
Wasn't talking about validity and.
No, but it did refer to the fact that this was avoidable marriage and reference
It
that
wasn't
statute.
exploring this sort of thing.
No, I accept that it wasn't exploring forced marriages in that sense, in terms of whether it should be avoidable marriage or not. It was identifying that it was, and it still is, and that is indeed still the case. So, in my submission, as far as the circumstances of a judge who has to take a view about whether the statute applies, it should be explained why the statute does not apply, and that must be justified before the judge. Then it says, there is a gap, I am now going to use the inherent jurisdiction. Otherwise, the inherent jurisdiction is just being treated, in my submission, as another option versus the statute, and it's not.
I thought your submission was that there is no gap.
Yeah.
But in very highly exceptional circumstances,
Correct.
notwithstanding there's no gap because the statute applies as per Mostyn,
Yes.
you can nevertheless make a declaration.
Yes.
I'm not sure on that analysis that your submission must be there isn't a gap.
There isn't a gap in this case, is my position.
Or in any case,
Oh, no.
because you'd be saying it's the exceptional circumstances that render it possible to
exactly.
go behind the statute, you would say.
Yes.
But what's the gap there?
Sorry, my lady. I think I haven't quite understood the point. As far as let me set out clearly the position of the appellant. It is that in exceptional circumstances, the inherent jurisdiction applies where there is a gap. But in order to get there, to use the inherent jurisdiction, the judge has to identify the gap and show why the statute doesn't apply. That was not done in this case. Otherwise, you don't go to the inherent jurisdiction at all. It doesn't apply. Our submission in this case is that it did not apply because there were not such egregious features that took it outside the intentions of the statutes, plural, and that we have 2 Law Commission reports, 2 statutes, which set out where the court should have been. There was a remedy, indeed 2 remedies potentially available, and what happened was that in this case the judge opted for a remedy which in our submission was not available and treated the inherent jurisdiction as an alternative, another option, as my learned friend for the local authority said, part of the toolkit. And it isn't. It is a safety net. That if the statute is not covering the case, then the safety net is there. And that's when the inherent jurisdiction, which is untouched and remains, applies. But if the statute has said it isn't there, well, you can't go there. And if you want to go there, then you have to show why the statute doesn't apply, and that was not done. My lady, if I can assist the court any further.
That's very clear, thank you. Anything else? Thank you very much. Well, as we've already indicated, no one will be surprised. We're going to reserve our judgments in this very important and difficult cases. We're very conscious that the family are all going to be waiting anxiously for our decisions, and so we will get your decisions speedily as we can, but we make absolutely no promises as to exactly when that will be. In the normal course of events, you'll all each be sent a copy of our drafts. That will enable you to look at typographical and grammatical and any inadvertent factual errors. It's not an opportunity to re-argue the case. May I remind you all of the terms of the new embargo that will appear on the top of the draft, and you'll all have to send a list in. We take that extremely seriously, and if you could each advise all your teams of the importance of that, and a breach of an embargo is potentially a contempt of court, and we take it extremely seriously. I'd hope that having received our draft judgments, you'll be able to agree any orders. If you can't, we'll deal with any applications in that respect in writing. And I thank all of you very much, including all the teams and those sitting behind you. So I'm very conscious of how much work goes into getting the four of you on your feet in front of us. Thank you very much.
What time?